morning. It's called The Lawyer Day. Attorney Corey Morgan here. This is, of course, not the day of the month Corey is normally on, but you had to be you had to do some work toward making a living sometime.
Oh, I know. Yes, and I had a jury trial last week, and I'm sorry I couldn't.
It's all right.
Couldn't make it at that time.
When it comes down to doing your work for which you're trained, and being on the radio, I think maybe you pay close attention to your legal duties first. We can always rearrange the radio.
And I appreciate that. Yes, I have to eat. That's for sure. Got bills to pay.
Right. That's what you do, so you got to do it when you have the opportunity to do it.
That's exactly right. And a lot of times I don't have the, if it's appointments or something, certainly I can change my schedule, but I can't for court. Court tells me when to be there, and I have to be there.
You say, Your Honor, I can't come that day. I got to be on the radio. What would the response from the court be, do you think?
I don't know. He might just go ahead and hold me in contempt and put me in jail. Just let me sit there until, I don't know.
If you're going to broadcast, you're going to have to come to the jail to interview.
But I will say he probably has tremendous respect for you, so he very well might say, we'll just come in later. I don't know. I was afraid to ask. I didn't know.
Right. Yeah, I wouldn't ask either. All right. We're going to take our first commercial break, and of course, Attorney Morgan here to answer any legal questions you have. And he was talking about making a living, but he doesn't make any living off of this one because these answers are all free. So give him a call. Locally, 270-726-6100, or long distance, toll free 1-888-610-WRUS. That's 9787. Get your question in. Attorney Morgan will answer them for you. We'll be back right after these.
At Young Funeral Home, we realize there's no such thing as a one-size-fits-all funeral. That's why we offer a full range of services and monuments, because everyone deserves a personalized service that reflects their final wishes. This is Wayne Reeves. If you have questions about pre-planning a funeral service, I invite you to visit Young Funeral Home. We will help you create the service you want without leaving the task to your grieving family. Young Funeral Home with chapels in Russellville and Auburn.
Diabetes is a growing health threat in our society. Take advantage of a special opportunity being offered this Saturday at Riley White Drugs and Healthcare on the Russellville Public Square. It's a diabetes risk assessment event organized by Russellville's own Kimberly Baugh and assisted by other students from the University of Kentucky College of Pharmacy. You'll be able to get diabetic screening and assessments to spot diabetes early on and begin the process of getting it under control before it does damage to the body. At Riley White, they'll be offering valuable information on what to do if you have diabetes. You'll learn about a good diabetic diet and proper lifestyle, and lots of information you need on management of diabetes to have an enjoyable life. Stop by anytime between 10 a.m. and 2 p.m. this Saturday at Riley White. And did I mention, this event, open to the entire public, is absolutely free. That's right, this diabetes risk assessment event is absolutely free this Saturday at Riley White Drugs and Healthcare in downtown Russellville. And Attorney Corey Morgan is here. What was running through your mind as you came over this morning, Corey?
Well, I thought, first of all, I just wanted to mention, I've said this before. Of course, I've been doing this for many years now, so I've probably said about everything.
Doing it, Corey? I lose track of the years. I'm
thinking maybe 08 or 09.
I'll say, we've been doing this for a couple of years. I realize it's been a decade.
It's been at least 6 years. I think more like 7 years.
Okay, I interrupted you there.
No, you're fine. I was just going to say that whenever you loan money to somebody, and this is mainly for parents out there in particular, if you loan money to your children, make sure you get a security interest of some kind. For instance, if you buy your child a car and the child's going to pay you back for the car, take a lien or a security interest in the car. And it's not because you don't trust your child. It's because what if the child files bankruptcy? Right. Then the bankruptcy court, all of a sudden you got an automobile that's free and clear that might go to creditors. What if something were to happen? Like I've seen cases where something happens to the child and then that car is up for grabs for creditors. Whereas if somebody's got a lien in it, then it will automatically be able to repossess that vehicle. So I mean, it's really that's just an example, one example. But whenever you do that, it's not that you're not trusting your child. You're actually helping your child by taking a lien. You can always release the lien later if you want to release it or whatever. But it's there in case, to show it's a true transaction and all that sort of thing.
Do you have any general suggestions about lending money to relatives?
Don't do it. That's my general. I see problems all the time like that. But it's real easy to say don't do it. But if you love your child and you want your
or other family members,
and parent or whatever, you may at some point want to do that and understand that. But it is certainly a risk, and it lowers the risk if you do take a security interest in things.
All right, very good.
What I was going to do this morning until we get some phone calls, I was going to talk about privileges. I don't think I've ever talked about privileges on here. Maybe just very, very general. What that means is, like in the rules of evidence, there's something called privileges. Most people are familiar with attorney-client privilege.
Right.
What that means is if somebody comes in and speaks with me as an attorney, then that information is privileged.
That's kind of like a priest and confessor.
It is. Mm-hmm. Yes, and that's one of the things too. Now, in the rules, it's got a general rule here. It says, except as otherwise provided by the Constitution or statute or the other rules promulgated by the Supreme Court of Kentucky, no person has a privilege to 1, refuse to be a witness, 2, refuse to disclose any matter, 3, refuse to produce any object or writing, or 4, prevent another from being a witness or disclosing any matter or producing any object or writing. What that means is, if you've got court, I don't care if it's small claims court or if it's, something that's much larger, you have the ability to subpoena someone to come in and talk for you. But if somebody is subpoenaed and comes to court, they can't say, nope, I'm not testifying. And that's what they're getting on the privileges here. You have to testify. You have to produce whatever documents you're told to produce, things like that. If there's an issue relating to that, you can file a motion to quash the subpoena. You're asking the court to not hold you responsible or not make you testify or not make you produce certain documents or things like that, because you'll have some sort of harm. For instance, maybe I was in the hospital and I couldn't make it to court. I could ask the court to quash the subpoena. Maybe I've got some sort of information that's patented that I don't want to get out to people to know about. Well, I may ask the court to quash the subpoena so I don't have this information out in the general public of information that is private in nature. There are different reasons you can do that, but privileges mean essentially that you don't have to produce either testimony or documents to the court. For instance, say, trying to think of an example. Well, here's an example. Say there is someone who is charged with methamphetamine. Mm-hmm. Or I should say suspected of methamphetamine. They haven't been charged yet. But the person goes to their attorney's office and speaks with the secretary. Say the attorney's not there, and they speak with the secretary and say what's going on and all that. Well, what if the Commonwealth, the government, decides they're going to subpoena that secretary to the grand jury? And the question is, can they do that? And the answer to that would be no, because of the attorney-client privilege. If you go into an attorney's office and you're asking the attorney questions or trying to get legal advice, and I'll just read the rule. It's probably easier than doing that. It says, a client has the privilege to refuse to disclose and to prevent any other person from disclosing a confidential communication made for the purpose of facilitating the rendition of professional legal services to the client. So if it's a confidential communication, then the lawyer cannot give that information, even if subpoenaed to court, or something like that. The lawyer can't give that information because it's attorney-client privilege.
Disbarment?
Yeah, you can get in a lot of trouble.
Suspended, disbarment.
Exactly. So that's one of the issues that you have, and that's not an issue that comes up very often. Every so often, you'll see something where maybe an attorney might ask something of your client that's attorney-client privileged information. Mm-hmm. But generally speaking, if I write down information related to a client that is privileged, that is actually called work product too. They cannot be, discovered, in discovery proceedings, and cannot be brought before the court, that sort of thing. Any communications I have between my secretary In me, that's privileged. Anything that the client says that if the client is doing it in a way that is to be confidential communication for legal advice, then it is something that the attorney-client privilege.
Let me ask you about a witness. This is not an attorney, but you're right about the cases in Louisville where somebody is subpoenaed as a witness in court against somebody who shot and killed somebody else, and that person is scared to death to testify because they're terrified of that person.
Right.
That's probably not a legal...
There's nothing... I can't think of anything legally of why that person would not be required to testify.
I've heard of some instances of gang shootings in Louisville or something where somebody, a woman may have seen the thing and scared to death because she figures she's going to be next on the list. And there was one case where they were not very careful about it, and the defendant was sitting in the courtroom watching who the witnesses. Right. This woman was going to be a witness, and I think she later wound up dead, maybe, or something. So.
And what you find out a lot of times too, the person will be subpoenaed to court and come to court and be like, "Oh, I don't know, I didn't see anything. I don't know," you know. And they wind up lying to the court, which is horrible, but they're doing that for their physical safety. They're afraid there's something's going to happen to them, so they'll say things like that to try to protect themselves.
Let's take a call. Good morning. You're on the air with attorney Corey Morgan.
Hey, Corey, I got a question for you, my friend.
Sure.
If a person, and this has nothing to do with what y'all were just talking about. I don't
that's fine.
That's fine.
I don't loan money to relatives anyway, so that's not a big issue. But anyway, my question is this: if a person is ordered by the court to a rehabilitation, say in Texas, Tennessee, wherever the case may be, can that person check themselves out?
The answer to that is yes. The person can check themselves out. What it is that whenever the court orders someone, say, let me give you an example. Say I plead guilty, and as part of my guilty plea, I have to go to Teen Challenge. That's used a lot of times here in Logan County. Teen Challenge, which is a rehabilitation that's a 12 to 15 months, I think, generally, most of the time. I'm ordered to do that. Now, I'm not under the Department of Corrections or anything like that while I'm there. So I'm free to check myself out at any time. There's nothing holding me there. It's just that if I check myself out, the facility will notify the court, and then the court will send a warrant out to pick me up. But you can always check yourself out of it.
Oh, so you can check yourself out.
Can check yourself out, but you'll run the risk of the court issuing a warrant and picking the person up.
That's what I needed to know, my friend. I do appreciate it.
All right, thank you. Appreciate it.
Appreciate your call. And we welcome calls for Attorney Morgan.
Certainly do, and you can call about anything. And
it doesn't have to be what we're talking about. Any matter involving the law at all. We'll take your calls. Okay, go ahead. Okay, as you were.
Okay. I thought you meant go ahead to another caller. Right. Oh, yes, what I was talking about, and as far as calls go, you can call about any subject. Doesn't mean I want to know the answer. And I'll tell you, I'll try to be honest with you and tell you, hey, I don't know the answer to that. I don't want to just pull an answer out of the air, but because there's some things like, for instance, Social Security. I don't know much about Social Security. I know enough to be dangerous about Social Security or immigration. Don't know much about immigration. Don't know much about copyrights and patents. There's certain areas that I don't know a whole lot about.
Just like a Sam Cooke song. Don't know much about.
Yeah, exactly. Yeah, I don't know much about a lot of legal areas that we don't see. In a small. I'm practicing a small town. I know your small town issues, and I know things that come up. But if it's something beyond that, it's sometimes difficult. But okay, now getting back to privileges, there's the privilege, like I said, the attorney-client's privilege. So if somebody comes to me and says, I just need to tell you what could happen to me. I killed my neighbor, and buried him in my backyard. If somebody comes and tells me that, their question is, well, can I notify the authorities? And the answer to that is no, I cannot do that. I can only notify the authorities if it's something that's going to result in fraud, like in the future, or physical injury, or death or something of that nature in the future. If somebody's going to commit a crime, they can't.
If it says I kill my neighbor and tomorrow I'm going to kill the neighbor on the other side,
then I have to notify the authorities. Right. But if it's something that's already been done that somebody's asking legal advice about, I can't call the police and go, hey, there's a body in the backyard. Yeah. I can't do that. That's, in fact, I'll get disbarred if I do that, because this is taking stuff that's taken very seriously. Some things nobody's perfect. Attorneys are always going to make errors, and there's some errors that are disbarment. There's some other areas, they'll fuss at you type things.
Good morning. This feedback. You're on the air with Attorney Corey Morgan.
Good morning, Don and Corey.
Well, hello there, Brother Richard. Have you committed a serious crime and you need an attorney this morning?
Not that I know of.
Okay.
Mm-hmm. But what I wanted to ask, I hear a lot about when you're thinking about the fact that you may not be around for very many years, that you're already in your 80s, that probate your state to avoid probate, getting a trust set up to avoid probate. What's your advice in a situation like that? Is probate a big deal here in the state of Kentucky?
Kentucky has one of the best probate laws in the country. A lot of trust companies will say, avoid probate, get a trust. I generally say avoid trusts, let it go to probate. And that's not always the case. Sometimes you do want to have trusts. Trusts have a very useful purpose. I don't do a lot of trusts from time to time. I may prepare one, but generally there are trust departments and law firms that prepare those things and all that. Trusts can be very expensive. They can be not only expensive to prepare, but also expensive to administer. So there's only certain times that you would want to have a trust. My advice when you get into areas like that is to always talk with an attorney before you enter into one agreement with one of these trust companies, because they'll try to talk you into getting a trust and things like that when you really don't need a trust. Sometimes it complicates probate. Sometimes it makes probate more costly. But a good probate attorney will be able to tell you whether you need a trust or not. In most cases I have found in Kentucky, in like rural areas and such, most of the time people don't need trusts. Now, if there's a lot of wealth that you're talking about, wealth transfers, and you may want to avoid certain estate taxes and things of that nature, you definitely need to talk to somebody who is an estate planning attorney who, in those type of cases, trust can be very, very important in estate planning. But just for the sake of getting a trust, most of the time people will do better if they do not have a trust and they just have a good solid will. Will do a lot that a trust won't do sometimes. Does that make sense?
Yes, sir. Thanks a lot.
All right, thank you. I appreciate it.
Thank you for calling. Let's take another call. Good morning. This is Feedback. You're on the air with Attorney Corey Morgan.
Yes. I'd like to explain the deal on that pretrial conversion.
Right.
Explain to me what it's all about.
What a pretrial diversion is? Is that your question?
Yes.
Now, and I'm trying to be very general because I know a lot of people are listening. Pretrial diversion is a criminal type resolution in a case, and there are different types of pretrial diversion. For instance, the criminal rules actually allow for a pretrial diversion, and a lot of your misdemeanor type cases may be diverted. Here's an example. Say I'm charged with assault, and the assault maybe assault in the fourth degree, which is intentionally causing physical injury to another person. Okay, that's how the statute reads. If I'm charged with that, the court may or I should say the prosecutor may decide to take it to trial. The prosecutor may decide that they want me to plead guilty. But if I'm like, hey, I don't want a guilty plea. I don't think I didn't do it. I didn't assault the person, or whatever. The prosecutor may get with the victim, and the victim will be like, well, I just want them to stay away. I don't necessarily want them to go to jail or be convicted or anything. I just want them to stay away. Well, in a case like that, in a misdemeanor case, you can enter into what's called a pretrial diversion, and that means that the case will be on hold with conditions that you don't violate the law and you don't go around the other person. That's what my pretrial diversion would say. It's not a conviction or anything. It's just a pretrial diversion, saying if in fact either of those two things occur, I violate the law or I'm around the person, then they can bring it back up on the docket. Okay, so it's just a resolution to try to get what you want to do. Usually, a pretrial diversion can be for up to 2 years in district court. Most of the time, they'll do it for a year. You know, most prosecutors will. Now, that's one type of pretrial diversion. That's a rule diversion. You can still, when you get to circuit court, which is the felony court where there's felonies, there's still the rule diversion you can enter into, but very seldom will a prosecutor want to enter into a rule diversion. The only time I've gotten rule diversions, I have a few times here and there over the years, is when there's just no evidence against your client, or your client's got a very good defense on something, and they won't do that. Most of the time they do something called a felony pretrial diversion. What a felony pretrial diversion is where you have somebody plead guilty to a crime. Hypothetically, say I am caught possessing methamphetamine. Well, I may enter into a pretrial diversion, which is I plead guilty to possessing methamphetamine. The court will not enter my conviction. I will not be convicted of a felony unless I violate my probation. I'll be on probation for 5 years. I'll have certain terms of my probation, not commit any other offenses. I might be subject to random drug tests. I could be required to do some sort of counseling, drug and alcohol counseling or things of that nature. I would be subject to random searches and random drug tests, and trying to think of what else. That generally whatever the requirements are, I won't be allowed to be around convicted felons, things of that nature. But that will be my probation for a period of 5 years. If I go the 5 years without getting in trouble, then the case will be dismissed. And after that, I can ask the court to expunge my felony to where it shows I've never been arrested of a felony, and I get rid of it. But in the event I do violate the pretrial diversion, the court can enter my felony conviction, and then the court will determine whether or not you go to prison. The court still could probate you, but it could be whether or not you go to prison. So in my case, they could say you have 2 years pretrial diversion for a period of 5 years, like 2 for 5. That means if I violate conditions of my pretrial diversion, I could be required to have a conviction entered for a felony for a 2-year period. And the court determines at that point whether or not to probate my 2 years or require me to actually be sent to the Department of Corrections. Do you understand what I'm saying, sir?
Yes, I did. Thank you very much.
Oh, you're welcome. You're welcome.
Hey,
yes.
Thank you for calling. Attorney Corey Morgan here. He'll answer your legal questions. No charge today. Of course, never any charge when he's on the radio. Attorney Corey Morgan will answer your legal questions. Call us up right now, 270-726-6100, or long-distance toll-free 1-888-610-WRUS. We'll be right back.
The holidays. The smell of delicious goodies drifting from the kitchen. The happiness of time spent with family and friends. The agony of hearing.
Are we there yet?
Get ready for the holiday season with a visit to Freeland Chrysler Dodge Jeep Ram. Call 725-4100 today to schedule routine maintenance with the Freeland Service Department, where an oil change starts at just $19.83 and an oil change and tire rotation is $29.67. If you need new tires, you can buy 3 and get 1 for $1 at Freeland. As a full-service dealer, Freeland offers a terrific selection of brand new Chryslers, Dodges, Jeeps, and Rams. Plus, Freeland has over 40 pre-owned vehicles on the lot. This holiday season, carry your casseroles in style with a brand new ride from Freeland Chrysler Dodge Jeep Ram. 1451 Bowling Green Road, Russellville. Call 725-4100 and shop or schedule service appointments online at freelandcdjr.com.
Unit 121 responding to a possible carbon monoxide poisoning.
Carbon monoxide is an odorless, colorless, tasteless gas that kills more than 500 Americans every year. It's produced when any fuel, such as natural gas, is burned, like in water heaters and gas furnaces. If you have a gas furnace, you need to have your heat exchanger checked every year to prevent harmful carbon monoxide leaks. Right now, you can get a furnace check and clean for just $55 from Knight Electric Heating and Cooling. Call 270-726-3818 to schedule your appointment today. Knight Electric provides reliable service 24 hours a day, 7 days a week, so you're never left out in the cold. When you call, be sure to ask about new prices on York package units and 14 Sear heat pump systems, which qualify for TVA rebates from their E-Score program. Remember, carbon monoxide can affect everyone, especially infants and children. Protect your family. Call Knight Electric Heating and Cooling today, 270-726-3818.
Stuff your shopping cart full with savings from your Russellville Piggly Wiggly. This week, family pack fresh pork chops are $1.29 a pound, and fresh fryer leg quarters sold in a 10-pound bag are 39 cents a pound. Red Rover Jonathan apples in the 3-pound bag are $1.99, and California Sweet Halos clementines in the 3-pound bag $3.99. Campbell's Chunky Soups are 2 for $3. Blue Bunny ice cream flavors 56-ounce size 2 for $5. Pick up a family-sized box of Betty Crocker cake or brownie mixes for 99 cents, or stock up on Kool-Aid Jammers in a 10-count box for $1.88. Don't miss out on the huge Kraft $8 sale when you purchase 8 participating items in one transaction. Get Kraft cheese varieties and Kraft Philadelphia cream cheese for $1.49, or Maxwell House Ground Wake Up Roast Coffee $5.49 a canister. Or Ida potatoes or onion rings are $2.29 a package. Again, all items are prices after the sale. Get savings galore all over the store at your friendly and convenient Piggly Wiggly in the Bethel Shopping Center, Russellville.
Attorney Corey Morgan. One question, Corey. People,
sure.
A lot of the public will complain about plea bargaining. Mm-hmm. If plea bargaining did not exist, the court system would be paralyzed, wouldn't it?
It would.
You could not. There'd be no way to take everything to trial.
Absolutely. There's a couple things I want to mention on that since you brought that up. Mm-hmm. Number one is many people are overcharged. They are charged with things they did not do. When police officers charge, they'll throw the book at people, and they're actually overcharged. So if they pled guilty to a lot of the things that they're charged with, they would actually be pleading guilty to things they did not do. Okay, and it's. I wish I could give a good example right now, but I see that all the time, and it's not anything against police officers. If I'm a police officer, I'll do the same thing. This is the police officer's way of saying, "Hey,
charge as many as you can to see what sticks."
Exactly. That's what they do. That's really being a good police officer. Mm-hmm. If you're trying to charge somebody with a crime, you want to charge with everything they can, and let the prosecutor determine what it is. Then the prosecutor will look at that, and the prosecutor will determine, "Hey, I can get a conviction on this. I can't get a conviction on that." Because sometimes the facts, once you look at the facts and once you find out what the context of things are, sometimes things out of context, it sounds horrible. When you look at the context, it really makes it to where it's not as bad. It's not quite what you think it is at first blush. So that's why the prosecutor will do that, because the prosecutor has to think, well, and I know this because I was a prosecutor. You think, well, am I going to get if I go to trial on this, if I put it in front of a jury, is the jury going to convict them? If they're charged with wanton endangerment and DUI, and I'm thinking, well, gosh, it's very unlikely they'll get convicted of the wanton endangerment, and they might not get convicted of the DUI. I don't know. You never know what's going to happen. So if I get the person to plead to the DUI, dismiss the wanton endangerment, then I've got a conviction for the DUI that's certain. And I don't have to worry about because what it does, it creates certainty. The prosecutor is uncertain what the jury's going to do. The defense is uncertain what the jury's going to do. But if they come to an agreement, then that is certainty. The prosecution sometimes will take things to trial, and the jury may acquit. You think there's evidence there, but once they hear the defense side, they may acquit. But if they lower it to the lower charge, the defendant will plead guilty, and they get a guilty plea that they otherwise wouldn't get. And you don't have the risk of the jury acquitting someone. So it's something that's done because of economics. Really, it's you cannot afford to try everyone. You do not have you'd have to hire 5 more prosecutors to try every single case. So that's why you have those. Good
morning. This feedback, you're on the air with attorney Corey Morgan.
Yes, Mr. Morgan.
Yes.
I'd like to find out if you have several misdemeanors on your record. How would you go about getting those removed from your record if they're 5 years and older?
There is an expungement statute that talks about when you can expunge cases. Unfortunately, in Kentucky, they're very strict on the cases they allow you to expunge. There's, just like you said, there's a 5-year look back period, and a lot of things can't get expunged. What they've recently done is required, and I found this out because I was expunging something a couple months ago. They have it now to where you fill out a form, and I think it was shoot, I'm trying to remember who it was. I think it was the Administrative Office of the Courts, maybe, that will tell you what's eligible to expunge and what's not eligible. So there's a form that you fill out. You can get from the Office of the Circuit Clerk in whatever county you reside in, or get that and send that off, and they'll tell you what you're eligible to expunge and what's not.
Say like they're AIs and PIs, they're 5 years and older.
I'm not sure. I know it's just very, very restrictive anymore on expungement. They're trying to, the legislature is trying to expand the expungement statute to where you're able to expunge more things. I think the legislature's finally realizing that if you're trying to protect Kentucky citizens, you want the Kentucky citizens to be able to have their records to where they can get jobs and things of that nature. But I will. What I'm going to do is look on my iPad here and try to find that statute so where you can read it and get a good idea of what you can and cannot expunge. But there's a 5-year look back, and I can't remember if it's beyond that, if you'd be able to do that. So it's probably not. It would be my answer, but. It's, they're just right now. At some point in the future, you probably will be able to, though.
So who would I talk to in the court?
The county clerk's office. They should be able to give you a form about expungement.
I thought you said circuit earlier. Is it county
clerk?
Did I say
county? I'm sorry. You were right. The circuit clerk of the county.
Right.
And that's where you go, in the courthouse, and it would be in the courthouse.
Okay, thank you. Have a good day.
Thank you. You
for
too.
Calling. All right.
Thank you for catching that.
Good morning. This is Feedback. You're on the air with Attorney Corey Morgan.
Yes, sir. Thanks for taking my call.
Sure.
Mr. Morgan.
Yes.
I was going to hire a young man about 2 weeks ago, and I had a background check done on him.
Mm-hmm.
That about 3 years ago, he had been in some trouble.
Right.
Well, the court dropped the cases against him.
Mm-hmm.
Just like 3 weeks ago or 2 weeks ago, the report come back that it was still on his report, said it was charges pending.
Mm-hmm.
Well, he had to go to his lawyer. He went to his lawyer this week and got a copy of it where it had been dropped and everything. Well, how can that still take so long 3 years ago and still be on his record as charges pending when the judge dropped the charges?
Somebody made a mistake. Yeah, go ahead. I'm sorry.
Let me hang up and listen.
Okay, yeah, I'll be happy to tell you that. I had something like that come up, I guess it was about 6 months ago, where somebody had several charges that were showing up. I remember.
The civil authorities have issued a required monthly test for all of Kentucky beginning at 9:37 a.m. and ending at 9:52 a.m. Russ. This is a coordinated monthly test of the Kentucky Emergency Alert System. In cooperation with federal, state, and local officials, broadcasters are testing equipment to ensure that you may be quickly warned in the event of an emergency. This has been a required monthly test of the EAS network. No action is needed. This is only a test.
Corey, I guess if I thought to look on the schedule, I would have known.
That's no big deal.
Now, okay, go ahead.
I was saying there was a gentleman I had represented that was, he had a case, they charged him with, I'm trying to remember, something like possession of controlled substance. It was a felony is what they charged him with. And they sent it off to the lab, and it turned out not being a controlled substance, and we were able to get it dismissed, and he wound up just getting convicted. There's several charges, and wound up just getting convicted like reckless driving or something. Well, due to his immigration status, they're going to deport him, and he's like, hey, they've got it listed in Kentucky that I'm been convicted of a felony, and we had to go through kind of a mess and get certified copies and everything and get it to the immigration, and long story short, everything worked out just fine, but there are some serious discrepancies and serious errors in those type things, because people, anytime you have people in something, you're going to have mistakes.
I think I made a mistake 2 or 3 years ago. I can't remember what it was.
I doubt that. I don't believe it. But
maybe it was 2 or 3 minutes ago.
But people do that. People make mistakes, and because of that, you've got to get those things corrected. What you're going to have to wind up doing is contact an attorney and get a certified copy of that. Get it to whomever needs it. A lot of times, if you'll notify the clerks, the circuit clerk's office, they can get it where it needs to go to make sure it gets corrected. But yes, there are lots of errors. Credit reports are horrible. Credit reports especially have tons of errors. And it's good to get your credit report, get a free credit report just to try to correct some of the errors on it. And I've said this before, but you can get a free credit report from www.annualcreditreport.com. Annualcreditreport.com. Go to there, free credit report from each of the 3 credit reporting agencies. You get one per year from each of the 3 agencies, and without a charge. It does not give your FICO score, the score that banks use. That does not have that, but it does have, all the information that they've been given, which a lot of times is wrong, and you can dispute it and that sort of thing. So you might want to do that as well. I want to mention a couple other things. Do we have a call?
No, not now.
Okay, good, because I want to mention a couple other things. Number one, the gentleman who called about the expungement. If you go to Google, I like to use Google. I think Google works better than other search engines, at least for legal matters. If you type in KRS is for Kentucky Revised Statutes, KRS 431.078. 431.078. That is the expungement statute. And I sound kind of like when I'm talking about expungement, I'm beating around the bush a little bit, because I don't. There's a lot of requirements on here, and it's hard for me to say whether somebody does or does not qualify for that without actually looking at the statute. And that's why they want the administrative office of the courts, or whoever it is that looks at these expungements, to determine whether something can be expunged or not. For instance, it says that the petition shall not be filed sooner than 5 years after the completion of the person's sentence, or 5 years after the successful completion of the person's probation, whichever occurs later. Number 4 down here says the court shall order expunged all records in the custody of that court, and any records in the custody of other agency or official, including law enforcement records, if at the hearing the court finds that A, the court was not a sex offense or offense committed against a child. B, the person had no previous felony conviction. C, the person had not been convicted of another misdemeanor or violation offense in the 5 years prior to the conviction sought to be expunged. D, the person had not since the time of the conviction sought to be expunged been convicted of a felony, misdemeanor, or violation. C, no proceeding concerning a felony, misdemeanor, or violation is pending or being instituted against him, and F, the offense was an offense against the Commonwealth of Kentucky. So see, there's a lot of requirements, a lot of things that you have to go through, hoops you jump through before you're able to expunge something in Kentucky. And a lot of times that person not been at the time of conviction sought to be expunged, been convicted of felony, misdemeanor, or violation, that hits people a lot of times, because even if it's a speeding ticket, that can a lot of times keep things from being expunged that are earlier cases. Do we got a call?
You sure do.
I thought I saw it flash.
Good morning. You're on the air with Attorney Corey Morgan.
Yes, thank you.
Thank you.
I got a question.
Sure.
I'm an only child, and my father is getting elderly, and I was just wondering what would be the best way to. He has some commercial property and a residential property, to be able to maybe put this in both our names, so that when he passes, there's not a lot of inheritance on it, or survivor clause or something.
Well, it depends on what you're ultimately trying to do. If you're trying to maybe avoid having to pay taxes, which is certainly a goal that a lot of people have when they have estates type issues. The Kentucky inheritance tax does not apply to children, so it does not. There shouldn't be any tax on that, and unless it's a very large estate, typically the federal estate tax doesn't hit it. So if it's a tax issue, it probably can be. If it's not a tax issue, it could probably be dealt with just by a will. There's a couple ways to do that I see too. If you want to go something beyond a will, you can do a life estate. A lot of times people will do that. The life estate will be where you transfer property, like your dad will transfer the property to you, except he will reserve in it a life estate, saying he gets to stay there the rest of his life.
Right.
And that's, I see that. They used to be really, really common. They're a little less common now, but they're still, I still see them quite often. That's another way to do that. Or it could be, transferred into both y'all's names. That's very possible.
Well,
go ahead.
Is this something that you could handle?
Yeah, I can handle it. Any attorney that can sit down with you and talk about it, sit down with him and talk about it, we can figure out what the best way to do. Before you contact me, though, I would ask that, and I say this all the time, I would say to contact an accountant, preferably a CPA, and talk about the tax ramifications of it. Because a lot of times you might not want to transfer the property into life estate, because it might be better for you tax purposes. Because when you said it as a commercial property, that tells me right there that there's some tax issues that could come into play. And I'm not talking about estate tax or inheritance tax. I'm talking about income tax type issues. Because it does deal with the basis of property and such. Whenever you transfer property, there might be some depreciation issues that come into play, and you want whatever cost you and your dad the least amount of money, whenever that is. So I would talk with a CPA first, and then whatever the CPA says. Generally, when the CPA says we need this, I do it, because I know that's important. Unless there's some legal reason not to, I usually will do what they want to do on that. Okay. So yeah. But you're welcome to contact my office. It's 586-7777, and I'll be happy to sit down and talk with y'all about it.
Okay. Thank you.
All right. Thank you.
Thank you for calling. We'll take one more break. Be back with attorney Corey Morgan right after these. Diabetes is a growing health threat in our society. Take advantage of a special opportunity being offered this Saturday at Riley White Drugs and Healthcare on the Russellville Public Square. It's a diabetes risk assessment event organized by Russellville's own Kimberly Ball and assisted by other students from the University of Kentucky College of Pharmacy. You'll be able to get diabetic screening and assessments to spot diabetes early on and begin the process of getting it under control before it does damage to the body. At Riley White, they'll be offering valuable information on what to do if you have diabetes. You'll learn about a good diabetic diet and proper lifestyle, and lots of information you need on management of diabetes to have an enjoyable life. Stop by any time between 10 a.m. and 2 p.m. this Saturday at Riley White. And did I mention, this event, open to the entire public, is absolutely free. That's right, this diabetes risk assessment event is absolutely free this Saturday at Riley White Drugs and Healthcare in downtown Russellville.
Choosing a funeral home requires enormous trust. This is Joey Young. At Young Funeral Home, we've been earning the trust of Logan Countyans since 1959. Because we are a family-owned funeral home, we understand the importance of treating you like family. We invite you to call us at your time of need or come in and discuss the benefits of pre-planning a funeral with our staff. We create personalized services that honor your loved one. Young Funeral Home with chapels in Russellville and Auburn.
Let me ask you something about a life estate. Suppose that a father is, there's a life estate. The father can live on the farm or the home until his death. Suppose the father with the life estate says, I think I want to sell this place. Would he have the right to do so if there's a life estate, or will that be only the calling of the son who is going to get the property when he passes away?
Right. Say you've got a father that has a life estate, and then what's called the remainderman, the person it goes to afterwards, the son. The father could sell his interest in the life estate, but that would only be for his life. So I think it's called life per alter ve or something. I'm going back to law school. I can't. There's a term for it.
Could not sell it permanently then.
No, it's just you have to have both parties. You have to have everybody who has any sorts of interest in that property has to sell it. Now, if they want to sell it to somebody else and the father and the son agree, then it can be transferred to somebody else.
Okay, let me ask you, we're talking about records. Well, what about juvenile records? What are they? Are there any circumstances in which juvenile records are opened, or are they always closed, or what?
They're always confidential unless the person is going to be tried as an adult.
Okay.
If the person's going to be tried as an adult.
Can go back and bring up juvenile offenses or you mean, no, if they're trying the person as an adult.
Correct.
In this particular case.
Then it becomes open.
Now, when does a juvenile get tried as an adult?
There's certain, there's like a lot of rules on that, and we're probably out of breaks, aren't we?
Okay.
So say I could look it up and tell you what it is, but generally speaking,
you can talk about it next month.
Generally speaking, if the child is between certain ages, and it's certain levels of offenses, the greater the offense, the more likely it is that the person can be tried as an adult. And if they're older, they're more likely to be able to be tried as an adult.
One more thing I was thinking about. This makes national news all the time. Say, I would never confess to something I didn't do. But we're hearing more and more stories about false confessions. And people serving 20 years in prison and being freed because the DNA didn't match. And says he was pressured to make a false confession. Thought if I told them what they wanted to hear, then they'd let me go home. And there are a lot of those false confessions.
There are, and people do that, and that's why it's so important for police officers not to be able to use like torture type techniques, and I know that I'm not saying that police officers torture anybody. I'm just saying, don't withhold water, don't withhold food, don't do things that will get somebody to say whatever it is you want to say, so that person can get what they need. And I know most of the time police officers are above board. I from time to time will see a police officer that I think puts too much pressure on somebody. But if you put too much pressure, you might be pressuring them into saying something that is not true, just to get them to leave you alone. And I think the same thing too. I think, oh gosh, I would never confess to something I did not do. But it happens all the time, and I guess under a certain amount of pressure, you confess like in Salem, you confess to being a witch if there's enough pressure against you.
And I'm thinking of something else. To satisfy the parole board, you may be totally innocent, but the only way you're ever going to be freed if you admit guilt and remorse. And it'd be pretty hard to say, well, I understand you're not going to grant me a parole because I'm not going to admit guilt and remorse because I didn't do it. But that's pressure too, isn't it?
It is. Yeah, they do that. Our society puts a lot of pressure on people to lie. And, I can give several examples of that. In the legal system, like we're talking about, that you get certain amount of pressure. Like when they send somebody to a counselor, the counselor will be like, well, they'll send something back. I can't counsel them. They won't admit, anything. Well, if the person doesn't think that they're an addict, they don't think they're an addict. Do you want them to lie about it? You want them to lie and say, oh, this is the case? And unfortunately, most of the time, that's what happens. That person will lie just to get whatever the person needs to get, because they'd be like, well, I'd rather do counseling than go to jail, so yes, I'm an addict, yes, say whatever needs to be said. And that's a shame that society does that, but that's one of those things that happen. There's a lot of problems in the legal system, and as long as it's run by people, there will always be a lot of problems in the legal system. It's had problems since inception, and it will have problems forever. I don't mean to sound too cynical, but you're not trying to make it perfect, you're just trying to make it better. And each generation you hope makes it a little bit better than the last generation has made it.
Go ahead. No, I was just going to say about there. Are there some of the other things you were talking about earlier you wanted to...
I did want to elaborate on a couple of things. The pretrial diversion, the statute. And once again, you can just punch this into Google. Aren't computers wonderful? You just punch this into Google, and it'll pull up the law.
I always say I'm fortunate that Google did not exist about the time I first dated Vivian, because if you'd Googled me, it would have been over from that first day.
It's a good thing topics didn't exist.
Topics, that's right.
Yeah, that's something. But anyway, what I was getting at is Google is great to find the law, and unfortunately, I have to sometimes tell people, hey, that's not what the law is, because you'll see general legal stuff, but if you go directly to Kentucky statutes, you usually won't go wrong on that sort of thing. But if you type in KRS 533.250, that's KRS 533.250, that is the pretrial diversion statute that the gentleman had called in about before, and it talks about a pretrial diversion program in each judicial circuit. That's the felony pretrial diversion. And the statute I'm looking at says effective until January 1, 2016. They actually have a new statute for felony pretrial diversion that's going into effect January 1 of 2016. So I probably should read that before January 1, because I haven't even looked at it yet, but because we're just still operating under the old statute. So I'm not sure what changes they're making, but that's one thing about this show too. I never know what direction it's going to go. So had I known, I would have already looked at the new statute and figured out what the changes are. But anyway, just some of the things that are, not everybody's eligible for felony pretrial diversion. It says this program may be utilized for a person charged with a Class D felony, which is the lowest level felony, that's 1 to 5 years, offense, who has not within 10 years immediately preceding the commission of this offense been convicted of a felony under the laws of this state, another state of the United States, or has not been on probation or parole, or has not been released from any service of any felony sentence within 10 years immediately preceding the commission of the offense. The next one says this program should not be utilized for persons charged with offenses for which probation, parole, or conditional discharge is prohibited under KRS 432.045. You can look back at that. Those will include things, such as sex offenses and things of that nature.
Got one more call here. Good morning. You're on the air with Attorney Morgan.
Well, Corey, this may be a dumb question.
There's no such thing.
Okay. Who acts as prosecutor? Can you be a prosecutor? Are you a defender only, or how does that work?
That's a good question. I love when people call up with questions like that. That's not a dumb one at all. I cannot act as a prosecutor. I can only act as the defense attorney. If it's a criminal matter, I can defend someone, but I cannot prosecute on someone. I think some states still allow private attorneys to prosecute. They used to. I think England used to allow that as well. Anybody could prosecute on something. If you're a lawyer, you could prosecute. But the way it is now, the Commonwealth attorney and the county attorney are the ones who prosecute on crimes. They're the only ones who are allowed to prosecute.
However, you've been a prosecutor.
I've been a prosecutor.
And did you work for?
I worked for the county attorney's office. I was assistant county attorney. Okay. I did primarily misdemeanors and DUIs.
So you can run for any of these offices, but if you're not hold that office or work in that office, you can't on your own then prosecute.
That's correct. Yeah, okay. I would be unable to prosecute unless I was actually Commonwealth attorney or county attorney. Commonwealth attorney does all the felony offenses. County attorney does primarily the misdemeanor and traffic offenses. That's the way it's separated in Kentucky, and they're both elected offices.
Does it help you to be a defense attorney by having been a prosecutor at one time? Does it give you a little more perspective?
Tremendously. I think if anyone gets out of law school and they decide they are wanting to be a defense attorney, they should be a prosecutor for, doesn't have to take long, 2 or 3 years to get a good idea of how that works, and then they can, at that point, switch over to defense attorney, and how the other side thinks. When you know how the other side thinks on things, it helps tremendously, because you think, well, if I were in his or her shoes, how would I prosecute this? What would be the weaknesses in my case? And if you can see it from the other side, it helps tremendously in being a defense attorney and being able to advise your clients on what their problems in the case are and trying to get it resolved in a way, and that's where we get into plea bargains, like you're talking about, and they like to call them plea negotiations. Now, that's because there's weaknesses in most cases. Some cases are pretty rock solid, but most cases you can find a weakness or two, and the plea negotiations, you plea it down to a different offense. A lot of times, and that'll be something that helps. And I tell you what's helped a lot of people, and we've got some wonderful prosecutors, and I wouldn't say it if we didn't. I just wouldn't say anything about it. But we've got some wonderful prosecutors, ones that try to help people who have drug issues. Right. And a lot of times somebody may commit an offense, but the ultimate problem is drug issues, and you want to try to get that person help. That's what I try to do as a defense attorney. The prosecution wants the person to get help. So, a lot of times you're actually working together to try to help that person to clean themselves up to where they don't have any future problems.
All right, we're out of time. Attorney Corey Morgan, always good to have you. WRUS, Russellville, Kentucky. Time now.